Clock in, clock in. Black gotta just walked in.
Yeah. He already dead, there ain't no need to check his vitals, bitch. He already dead, there ain't no need to check his vitals. Yeah, crunch time, yeah, nigga, it's lunch time. Let go, crunch time, yeah, nigga, it's lunch time. Yeah, crunch time, yeah, nigga, it's lunch time. Let go, crunch time, yeah, nigga, it's lunch time. He dead.
Team Black got a stand up, man. Yo. Right now we back with another video. And if you ask YNW Melly lawyer what type of video we watching a video of him in the court while the prosecutors are making this a fiasco. That was his exact words. Me, I could personally say, bro, it been so many objections. If I get $1 for every objection I heard, I would have a lot of dollars. This whole trial is just full of a bunch of sidebars. The judge getting aggravated with the prosecutor a lot because they say they not gonna do something and then they turn around right when the jury come in and still do it. Yeah, man, there's just been a lot going on, but let's get into this video.
I just started to do some research, and quite frankly, I've only candidly found a case. It's in the 4th DCA, but it concerns a civil matter. And it speaks of the need for a discovery cutoff to avoid the very term I used, ambush and surprise. And that when a party conducts itself in a way as to ambush there not to get the benefit of that. These trials, we understand, life goes on beyond trials. So the evidence that can be introduced into a trial should have some finite and determinable parameters. The notion that the state comes here and asks jurors to put somebody to death suggests that they have completed an investigation that warrants that co-signing, co-signature. To suggest that, okay, there are a lot of things that we could have done and we didn't do, and if you ask about it, we're going to go do it and introduce it while the proceedings ensue.
Not a good idea.
It's not only an ambush, but it's an insult to the process. They're saying that they have the evidence. Now, the state can get up there and say, hey, the defense is making some ridiculous cross-examination and we don't have everything because what we have is enough, which is when they bring an indictment of this nature, of any indictment, they're saying we have enough now, beyond a reasonable doubt. But what they cannot do is, as these proceedings go forward, continue to investigate and plug holes that we reveal to exist as the process goes on until this case goes to verdict. I'm not quite sure when this would end or how there is even a gatekeeping function of the court if there is no gate and there is no fence.
Ain't no gate.
And there are no lines and no parameters of propriety.
Okay.
The state is making a representation by bringing this indictment that they are ready and they have proof beyond a reasonable doubt. And if that proof beyond a reasonable doubt also includes areas of investigation that were not pursued, then they should explain to a jury why it was not pursued and why the failure to pursue it does not undermine their case. They don't get to keep plugging holes as the proceedings go forward. And so, as the 4th Circuit said, that is ambush. And the purpose of, the 4th DCA said that is ambush. And the purpose of a discovery deadline is to avoid surprise, avoid ambush, and a party that engages in that ought not to get the benefit.
So what he's saying is the prosecutors are bringing evidence that they never even discussed about prior. Like, why are they doing stuff they know they can't do? Like, it don't make sense to me. Now, I believe I'm not the only one who knows if this wasn't as serious of a case and it wasn't two people that lives were taken within this case, like this case would probably be mistrialed or probably over by now. Like, cause it's like they got this man stressing, the lawyer stressing. You feel what I'm saying? It's like his head gets shinier every day. But one thing I can say is this man got away with his words. He every time he step up to the plate, I'm knowing he gonna go crazy. Like, I'm knowing he gonna snap, cause his wordplay is crazy, and just the way he could real deal put you in his head and literally make you think about what you think about. You feel what I'm saying? Literally make you think that you tripping if you thinking something other than he is. Lawyer been going crazy though, y'all.
Thank you.
Thank you.
Hold on.
Just briefly, you mentioned that defense isn't yet to provide any reciprocal discovery, but alluded to some yesterday that they were looking at Instagram posts and everything that had happened as recently as this week, but yet they have provided nothing to the state. So if there's any deadline of any sort that needs to be imposed on both parties.
Thank you. Oh, Counsel, my understanding is that's the way it works. Is that it's not Richardson violations apply to both sides. It doesn't apply to just one side. It's deadlines apply to both sides.
Both sides.
That's not what we're talking about.
We apologize. The pictures to say start working. Let's work on it. I'm sorry.
I apologize. What I was saying is that the whatever obligations that are imposed would be applicable to both sides when there's a discovery cutoff or not. My thought is as to the discovery cutoff, you can keep investigating the case, however you feel fit, and you're more than welcome to do that. However, that doesn't mean that anything you find can be used at trial as evidence. This thing with Mr. Moretti, where when I'm out of town on vacation, you're asking the detective, or he's offering, I'm not really sure how it happened, to continue and run this through another process, and the defense doesn't know about it. The defense cross-examines Mr. Zellner, or Officer Zellner, and is not aware that he's asking questions about other programs, because his understanding is there isn't any other program. But you know there's another program, they have access to it, and they've done it. You just don't have the results. That seems to me to be what the counsel's talking about. And that seems to me to be a Richardson violation. There's a discovery that's ongoing, you know about it, and you're not telling them about it until we're here in court. So as far as I'm already is concerned, I think that's a discovery violation. And I'm finding it to be a discovery violation. I think the only way it can be cured is he's not going to testify about this second procedure that happened. That's not coming in. Same thing. If you want to keep investigating a case, you can do it. You can find exculpatory information. You may change your mind as to how you proceed with the case, and I don't have a problem. You can investigate whatever you want to investigate. But as far as using new discovery that you're coming in, I think it
that's
needs
crazy.
to be happening, because this is what's going on. We're going to have this. If you find something new, there's a whole, as counsel describes it, that then you try to find evidence to plug up the hole that's new discovery. The defense doesn't have an opportunity to depose the witness. The defense doesn't have an opportunity to do X, Y, and Z.
She know that.
Not the way it should be.
She know that, Judge.
My surprise. So
it's clear this was not a new item. This was just this. All of the information was supposed to be identical.
you found it. You had a meeting with the detective in May when we're in hiatus because I'm on vacation. Right? You have a meeting with him in May after we picked a jury, and when we're ready to, or we're in the middle of jury selection. You picked it. You did it, and you said, well, he tells you, or you ask him, do you have more, programs to go ahead and provide the information, and you find out there's another program, and he runs the program, does a different download with something other than Cellbrite, and therefore, you have more information. Don't make the defense aware of it. You hold that to yourself. You go ahead and put on a couple weeks of trial testimony, and then when it comes up after he, in cross-examination, points something out, you bring it up and say, well, by the way, I told him, the detective in our pretrial meeting. It came up, and he has the program, and we can use it, and we're doing it. All right, and but you don't tell them about it. You just go ahead and hold it, keep it close to the vest yourself. Don't explain it to them, and then you say, when it comes up at trial, I say, what was it? I don't have the report yet. That's why I didn't turn it over to him, but didn't disclose it's coming. It seems to me that's not what's supposed to happen. Not supposed to happen, period. That's a discovery violation. Okay? So, as far as the Detective Moretti, and whatever other form he used, that's not coming in.
Okay.
All right? That's the sanction. If you have other information, other discovery that's in the works, you better share it with them, because right now, if you don't have it, they're not aware of it now. It's not coming in unless there's something extraordinary that pops up. And just because, you find out they have additional capabilities and you want to go retest something, that's not extraordinary on my way of thinking. I'm not familiar with what the case law says. It just seems to me that this is a fundamental fairness thing. You have evidence, you need to turn it over to him. If you didn't turn it over to him, you can't use it. That's really the basic.
Understood, Your Honor. And so everything has been
Real
turned over.
basic. She know that, though.
The only item of which there was additional investigation.
Talking about that's the only item.
There wasn't any other information or anything else that came out. It was reported to me that it was identical in terms of the information that was done through Gray Key versus Celebrate on that. So defense counsel is attacking the veracity of the Celebrate program on that. So with regards to that, that's the only reason why that would even be brought up. But if I understand there, so we can move forward on that. But I do want to address one other issue while we're outside the presence of the jury. Counsel keeps objecting to publishing of items that are already in evidence and making speaking objections. So just ask if Your Honor could address that specific issue, because the state can publish the items that are in evidence in the presentation of their case, and defense can object if there's something that has not been admitted or something to that effect. But in terms of the speaking objections and things like that, those are improper in front of the jury.
Thank you. All right, no speaking objections.
Judge was here looking like you just said all of that for no reason. What is your purpose? He like, okay, thanks.
When do you expect this documentation to come over?
I think the printer just started working.
And I provided it to Ms. Liberty.
Do you have those, Ms. Liberty?
Yes, confirmed, Judge.
Are you ready to proceed?
What's crazy is the prosecutors are purposely doing this. Like, this is not no accident. This is common sense. Like, whatever you don't show, you can't show. It's like they're purposely throwing these words and suggestions out there so everyone can hear. And it just, it creates an image like, oh, it's something that they could have used. And it just creates like this atmosphere of what that evidence could have been, man. But like, this is real deal common sense. And it's like, they're literally doing it on purpose because they know it is benefiting them in some way. Rather he goes on a stand or not, just mentioning it and bringing it out is gonna benefit them in some way for the crowd. And as much as the audience wants to see, justice being served, they don't want to see things going on in the courtroom that's not supposed to be done, But hey, I'm gonna catch y'all in this video. Let me know what y'all think about that.